Welcome to the Microsoft EU Tech Talk. Today, we are here to discuss e-evidence, which is legislation that allows law enforcement agencies to obtain data in the cloud. It could be personal communications, such as email, could be other types of personal data regarding location. My name is Lonnie Cosette. I'm a senior lawyer at Microsoft, and my guest is Professor Theodore Christakis, an international lawyer. He's a professor at the University of Grenoble Alpes. You have written a great overview of e-evidence. Tell us, in a nutshell, what this legislation is about and why EU citizens and companies should care.
Let me explain by using the example of a painting by René Magritte, which is called The Menaced Assassin, where you see a woman dead lying in a couch, and in front of her you have the assassin who is listening to a piece of music in the gramophone. And around them, there are plenty of detectives who are waiting to to arrest the assassin. These were the old days when you had a criminal case. Everything was in the room, so you just had to send people there, detectives who could get all the evidence there and arrest the suspect. Things have dramatically changed today in our digital world. According to a report by the EU Commission published in 2018, the EU Commission said that digital evidence, access to digital evidence is absolutely necessary in order to resolve more than 85% of all criminal cases, which means that today we need to access, in order to arrest the suspect, we need to access emails, we need to access photos and documents stored in the cloud, we need to access digital evidence. The problem is that very often this digital evidence is stored in another jurisdiction. According to the EU Commission, in more than 50% of all cases, the digital evidence is found in another country. For example, you have a crime in France committed in Paris, but the digital evidence is stored in Dublin in the servers of US cloud provider. And this creates a lot of problems, and we have realized that the traditional mechanisms of international law in order to resolve these problems, which means using the mutual legal assistance treaties, are not sufficient. So this is why countries are pushing with new laws, with new tools in order to be able to access the data. And the e-evidence legislative package, which was introduced by the EU Commission in April 2018, aims precisely to find a solution to this issue by organizing a mechanism where law enforcement authorities all over Europe will be able to request the data directly by the service providers. And in order to do this, you need to have a lot of guarantees and human rights safeguards.
And can you let us know, where are we in the legislative process? What's coming next?
What happened was that in December 2018, the EU Council of Ministers was able to adopt what we call a general approach, which means a draft giving an idea of its approach of e-evidence. This has been very heavily criticized by several NGOs, service providers, but also by several states. 7 states were opposed, including Germany, for example, or the Netherlands were very, very critical in relation with this draft approach by the EU Council. Then the ball was in the EU Parliament's court since then, and a very important development took place in November 2019 when the rapporteur of the LIBE committee in the EU Parliament introduced her report, and this report proposes 267 amendments to the initial proposal by the Commission, and an entirely different logic and structure.
Theodore, tell us, what are the building blocks to get e-evidence right?
I think that there are 3 major building blocks in order to get e-evidence right. First, we need to provide law enforcement people with all necessary tools in order to be able to access the data they need for criminal investigations in order to protect societies. Second, we need to do this right, taking care of human rights and providing all the necessary legal remedies and safeguards and control because there are risks of abuse. And third, I think that there is a need to provide legal certainty for service providers so that they will be able to challenge abusive orders or have other tools in order to be sure that they will be able to protect their customers.
So speaking of solutions and the member states and the safeguards, I understand there are some gaps in approach between the European Parliament and what the member states are asking for. Do you think that negotiations will be able to resolve some of the differences in what the solutions should be and what these safeguards should look like?
I am convinced that this is possible, and we must understand that e-evidence is a necessary tool for law enforcement. So we really need this tool, because otherwise, if we don't adopt this harmonized tool at the EU level, what will happen? Two bad things could happen. One is that law enforcement people all over Europe will try to get the same data because they need this data. So they will try to get them through informal mechanisms with absolutely no transparency, no control, no oversight. And this will be a huge problem for human rights. Or the second problem could be that we'll have national laws and a complete fragmentation of the system here with a lot of subsequent problems. So we need this tool. There is a real necessity. So we must achieve this, and I think it is perfectly possible to find solutions in order to strike the right balance. We need this tool, but we have to do it right, and we have to do it in a human rights friendly way. And for example, in the EU Parliament's draft report, there are some good mechanisms to think about, and I am positive that during the trilogue, we can find constructive solutions in order to strike the right balance.
And if you could look into a crystal ball, what will this final legislation look like?
Well, it's difficult to look at a crystal ball, but we are advancing ideas, and I'm convinced, for example, that precisely if we are able first to have a control and oversight of the affected state, combined, for example, with the solutions for the rule of law problems and with some other human rights protections, such as the one that I mentioned, notice to users, it will be possible to find a solution during the trilogues which will be workable for law enforcement people and good for human rights and service providers.
And looking into the future and beyond Europe, I understand that e-evidence will play a role ultimately in a negotiation between the US and the EU on data sharing. Can you give us a sense of how e-evidence will play a part in how this develops?
I think that e-evidence, of course, is necessary in order to have already a legal regime in Europe, but the EU-US negotiations create a lot of other challenges. And first of all, we have a huge issue of conflict of laws. Let me explain this point. Right now in the US, we have a law which is called the Cloud Act, which authorizes US authorities to request data from service providers irrespective of where the data are located. For example, data which are located in France. And this creates a lot of reactions in France, including people who are saying that this is contrary to the GDPR, to the General Data Protection Regulation. Which means that we can have a conflict of laws from this side. When e-evidence is adopted, it will do exactly the same thing, which means, for example, when a European country requests data from a service provider, this could conflict with American law, the Stored Communications Act. So we really need to find solutions. We need a transatlantic agreement which will be able to resolve conflict of laws issues and also ensure some other functions such as permit EU law enforcement authorities to access data which are stored in the United States. We really need this transatlantic agreement, but once again, I think that we have a lot of challenges, including one of the challenges is how are we going to be able to make a reciprocal agreement. This is a requirement by the EU to have a reciprocal agreement, including for targeting limitations in the legal regime, but precisely we acknowledge these challenges, and we think the Cross-Border Data Forum, and I invite you to visit our website, crossborderdataforum.org. We try to think creatively, and we try to avoid some intellectual traps that could hinder the conclusion of this necessary agreement, and instead to advance some creative ideas that will make it possible.
Theodore, thank you so much for being with us here today. We appreciate your insights.
Thank you very much for having me.